Good afternoon, everybody. Welcome to the RBKC Licensing Committee Subcommittee hearing. We're dealing with a problem or a case relating to 165 Draycott Avenue. This hearing is actually live streamed, so please be aware of that. And I'd like to introduce the committee members first. On my left is Councillor Pat Mason, and then there's Councillor Sarah Addenbrook. On my right I have our legal representative, Lindsay Mazurier, and we have governance officials here. And then I'd also like other people present to, before I do that, I'd just like to do the declarations of interest. Councillor Mason.
Nothing to declare on this premises, Chairman.
Councillor Addenbrook.
I have nothing to declare.
Thanks very much, and I have to say I have nothing to declare either. I'm not familiar with premises or the applicant. Would the applicant please identify themselves?
Hello, I'm Ashley Marison. I'm a director of Tribeca Holdings, and here on behalf of the applicant.
So, can you look into your microphone, please?
Sorry, can you hear me?
I'm going to warn you also. I have
this is my first time in the chamber. So my name is Ashley Marison. I'm a director at Tribeca Holdings in charge of real estate and leasing and development, and I'm here on behalf of Tribeca Holdings to, I guess, put forward our case for the premises license at 165 Draycott Avenue.
Thank you.
Good afternoon, sir. My name is Thomas O'Mayloin. I am from Thomas & Thomas Partners. I'm the solicitor representing the applicant this afternoon. Thank you very much.
There's nobody here from the objector side, but I would like to confirm here that we have read the papers submitted by the objector and the objector's representative. Thanks. As regards the procedure, each party has a maximum of 10 minutes to present the case and a maximum of 5 minutes to ask questions. Applicants will go first, followed by responsible authorities, of whom none are present today, and then will come other persons. And there will be no summing up. And also, we will deliberate today, but will not issue a decision, but we'll do so within 5 days, 5 working days of the hearing today. Are there any amendments, applicants to that, or everything is here on the table that we're aware of everything?
Yes, that's correct, sir.
Okay. Right, well, thank you very much. Licensing, would you like to present, would you introduce yourself, please, and present the case?
I'm Fiona Johnson from the licensing team. And should I just present now? Okay.
Yes.
So, good afternoon, everyone. This application has been submitted by 163 to 165 Draycott Avenue Limited for the grant of a new premises licence at the lower ground floor and ground floor 163 to 165 Draycott Avenue, SW3 3AJ. The applicant is seeking a premises licence to provide the sale of alcohol, both on and off the premises, Monday to Sunday, 10 a.m. to 11 o'clock p.m, and for the provision of late night refreshment, Monday to Sunday, 11 o'clock p.m. to 11:30 p.m. They've also applied for a non-standard timing. Within the application, the non-standard timing was for the end of permitted hours on New Year's Eve onto 0200 hours the following day, and the hours that the premises would be open to the public would be Monday to Sunday, 11 o'clock p.m. to 11:30 p.m. It's worth noting for the purposes of the committee that the original proposed non-standard timing were stated from the end of permitted hours on New Year's Eve onto the start of permitted hours on New Year's Day. This has since been amended following discussions with Environmental Health, who have proposed a terminal hour of 0200. The applicant has agreed to this 0200 terminal hour on New Year's Day. A copy of the full application can be found at Appendix A, and a plan showing the proposed layout of the premises can be found at Appendix B. The application itself has attracted a representation from one resident, and a copy of the representation can be found at Appendix C. A summary of the representation can be found on page 5 of the committee agenda. There is one slight amendment I'd just like to make to this report. It actually says on page 5 that at the time of writing the report, no noise complaints had been received in the preceding 24 months. On checking council records again, there were 2 noise complaints received. One was on the 1st of June 2021 in relation to noisy building works, and the other complaint was on the 12th of May 2019 for a noisy alarm. I can only apologise for that mistake. Council records also indicate that at the time of writing there were no temporary event notices submitted within the previous 24 months. This concludes the summary of this application. Has anyone got any questions about the report?
Hello, can I just clarify, the application is just in respect of 165, it's not 2 buildings, you said 163 to 165, I think that's the name of the company, but the actual premises are just 165 Draycott Avenue, can you just clarify that?
I can address that, sorry for the confusion. There were 2 applications submitted. One was for 163 and the other was for 165. 163 was granted under delegated authority because there were no objections, which leaves us 165. I think the confusion arises because it's the same company. It's the same company that owns both buildings.
And was it a similar application for 163 as to 165?
It mirrored this application, that's
So
correct.
they're both going to be restaurants?
Yeah. Exactly.
Within one unit or 2 separate
No,
restaurants?
two separate units.
Two separate restaurants.
But the one that was granted under delegated authority has been granted with exactly the same conditions that were offered in relation to this application.
Thank you. And these are both landlord applications?
That's correct.
Thank you.
And it's also correct to say that neither site are trading or have traded as a licensed premises. I know that the lady that has sent in a representation says that historically there had been. We've looked into that and it appears that there may have, or at least there was something there some 20 years ago, but certainly there hasn't been a licence at 165 since it was delegated to the local authority from the Magistrates' Court back in 2005.
I'd just like to confirm that is the case.
Can I just ask, Chairman, if these premises haven't traded previously, are these noise complaints attributable to these premises, or am I missing something?
Well, the first I heard of the noise complaints was this afternoon, but I would suspect that one was in relation to building works. I missed what the second one was, but what is correct and what I think is important for this application is that neither of the noise complaints related to complaints from a licensed premises. The complaints must have been in relation to when both of those units, which are still currently trading, as retail units. At the moment, to be clear, 165 is currently trading as a retail unit, and it's a pop-up retail unit.
Not your unit. Not.
Sorry?
Does it belong to the business, or
We're the landlords. We own...
or you're the landlord,
Yeah.
but you're not trading?
Yeah, so it's leased, exactly.
Right. Okay, thank you.
Councillor Addenbrooke, do you have any questions? Well, would the applicant like to present the case then, please?
Thank you very much, sir. If you're happy, what I was minded to do was to address you a little bit, well, primarily in relation to the objector and what her concerns are, and how I would hope that what we propose within our conditions can adequately address those concerns. And then I was going to hand over to Mr Morrison, who can give a bit more meat on the bone in terms of the landlord and in terms of the overall strategy and redevelopment of this area and what their vision is. So I think that would be helpful for the committee to have an overview of what is happening on Draycott Avenue. So if you're happy with that basis, first of all, sir, could I look or ask you to look at the plans of the premises? They should be contained within your papers. And I can deal with this very quickly, but I think it is helpful. On the plans themselves, you'll see that the lower ground floor, i.e. the basement, is in its entirety back of house, and we have public lavatories. So the only area where licensed activities would take place, if you're minded to grant, would be on the ground floor. And you'll also see that within the plan, you'll see that it is limited to 50 covers. So you can usually appreciate that the premises themselves are really quite tiny. In terms of the objector, you will have read her original objection, and it was also followed up with a letter from her solicitors, which also attached a further email sent by her to the relevant officer. If I could turn first of all to her original objection. The copy I have is undated, but it's the original one that was sent in to the licensing service. She confirms that she is the legal owner and resident of the flat, which is immediately above the premises, and then she goes into her various grounds of objection. If I could deal with these in turn. The potential for disruption to the quiet enjoyment of my residence in relation to loud music, overcrowding, and the effects of alcohol. I would suggest that our drafted conditions, and I'm looking, sorry for the sake of clarity, I'm looking at the helpful document that your legal advisor has provided, which is entitled Draft Conditions, which also has some extra conditions that they have suggested. But within that document, Condition 4 requests notices to be displayed. Condition 5, we'd have a dedicated telephone number. Condition 6, there'll be a condition stopping any music causing a nuisance. Number 7, that no noise or vibration would be permitted at the premises. And turning over the page at 9, that the premises cannot be used until the terms of this licence until they've been insulated, so as to prevent the transmission of excessive airborne or impact sound to neighbouring dwellings, etc. And at 14, it also deals with the ventilation and extract systems, also dealing with noise and odours, which of course she mentions there. And there was a concern as well about what may happen at her front door in relation to rubbish clearance, etc. And you will see that we have agreed to a condition. I can just find us in my notes. It's condition 10, which specifies that outside the pavement needs to be kept clean at all times and needs to be inspected, etc., throughout trading hours. I've already addressed you in relation to the historic reason that she refers to, that there had, in fairness, been a licensed premises, the precise details of which are thin on the ground, but it certainly is the case there was something there 20 years ago. It is fair to say, however, that since then, obviously, procedures and rules and regulations have been tightened somewhat. And in fact, the building itself has undergone a refurbishment. So the concerns that were raised in relation to smells from plant or in relation to sewage have already been addressed in full. It's also correct to say that the building itself has received acoustic treatment. In relation to the follow-up letter that was received from her solicitors, much of what she complains of, in fact, is repeated within that letter. I don't think I need to trouble the committee in relation to going through all of those conditions again. But I think there is a point that is raised by the solicitor, but also was raised by the resident, and that was in relation to the consultation. And I would like to let the committee know that immediately upon the application being submitted, there was a letter drop in the area which was carried out by the landlords. So local residents were made available directly through the letter drop. Obviously, which is a requirement, a notice was displayed at the premises as well, and of course a notice was placed in a local newspaper. It is unfortunate that that the objector clearly didn't have sight of the letter that was sent by the letter drop, and that is unfortunate because I suspect that if she had seen that and we had spoken before the hearing, I suspect that it may well be that the hearing probably would have been unnecessary. In terms of the extra conditions or the tweaks to the conditions that your legal officer has put forward, we have no concerns at all with the suggested tweaks to the conditions that we had put forward. In terms of the additional suggested conditions, which are 27, 28, 29 in the report, we would resist the need to have a local residents meeting. In our opinion, we would say that is unnecessary and not proportionate, A, for the size of the premises, and B, by the very fact there is one objector, and obviously within the conditions themselves, there is a condition saying that our number will be freely available, and so there is an avenue of communication already with her. The next condition that's suggested in relation to the bifold doors, we would be happy to agree to. However, if this were put onto a licence, if granted, we would request that the windows could be opened from 8 o'clock in the morning. Obviously, no licensed activities will be taking place at that time, but it may well be the case that on a summer's morning it would be quite nice to have the windows open from 8 until 10. And the final suggestion in relation to 29, we would resist this, but only because the premises are very small, and from experience you can have lots and lots of notices everywhere. We have already agreed to have the notices about asking people to leave quietly. If we have notices about a Challenge 25 up, we would suggest it's probably unnecessary in light of the fact that the licence would be fully conditioned as a restaurant, and it would be more usual to have such a poster notice in a retail space or in a supermarket, for example. And so we would resist that. Now I'm going to pass you over to Mr. Morrison, who will be able to give you a little bit of background as to the landlord and what their vision, as I say, is for the immediate vicinity.
Okay, thank you very much, Mr. Whalen. 10 minutes.
Hello there. We distributed a short presentation prior to this meeting, but I'm not sure if you have that on your desk. Do you have that?
Sorry, I could probably assist her. My apologies. We tried to send us, but in fact, we weren't able to open it. And I appreciate the rules of the committee. So it's entirely a matter, and I should have addressed this at the beginning, and my apologies. It's entirely a matter for you. The brochure is a series of photographs and street plans. I don't think it's in any way controversial. It might assist the committee just to see the overall picture of what is proposed in the area. If you feel uncomfortable with that, and I appreciate that it may well be the case that you don't want documents at the 11th hour, and also that the objector is not here in fairness to her, we can take you through the document orally. But as I say, I hand on heart, I don't think there's anything controversial within us, but it, of course, it's a matter for you.
Chair.
Yeah. I was just saying, all we've seen is one photograph.
That's correct. As
Just
it hasn't
one
been
photograph
given
of the
to
front.
Don't worry, I can talk you through.
And that was
talk
sent
us
as
through
a
it, that'd be
JPEG.
better.
It
Let's
wasn't
do that.
a
Let's do that.
PowerPoint or anything.
Just to give you a bit of background, Tribeca Holdings is a family-run property company. We're based in London. We're primarily focused on retail properties. Other ownerships include Old Spitalfields Market in the city and a block on Oxford Street. And we first came across Brompton Cross in 2010 and saw this as a location which I think back in the early 90s was one of kind of London's favourite retail villages away from maybe the West End, and had really great heritage as an area with high quality retail, high quality residential, and we saw this as an area that we would like to invest in and try and kind of continue its growth and reposition it to be one of London's best retail villages, akin to something like you might see in the borough with Westbourne Grove, which is very pretty, lots of retail, lots of mixed use, a number of restaurants. And that journey started 10 years ago. Our main ownerships, which you can't quite see, are in black here, and predominantly are around the Draycott Avenue corner and Walton Street, ownerships on Brompton Road, Draycott Avenue and Sloane Avenue. And to give you a little bit of background, we have introduced probably 17 new international retailers into this area in the past 10 years. We have invested over £300 million into 20 separate freeholds and created circa 35 shop fronts. I think what's also important is that within our ownership, we directly manage 30 residential apartments, all on assured short-hold tenancies, located on Draycott Avenue, located on Sloane Avenue, and a building you may know, which is Eldon House, which is the 1960s building on the corner of Sloane Avenue, Fulham Road, Brompton Road. It's a very kind of dominant building there. So, in our journey at Brompton Cross, we are very mindful of our local residents, of our retailers, and all our local stakeholders. We're very passionate about this area. Developments that we have done in this location have been a new 10,000 square foot retail store for Chanel, which sits at the corner of Draycott Avenue and Walton Street, and that was with the support of RBKC's planning team. That was an upsize for them from 5,000 square feet on the corner of Brompton Road and Fulham Road to a 10,000 square foot flagship, so that they could create a whole building for themselves. Other names that we've brought into the location to try and kind of create the village are names like Dalesford Organic, which again with backing from RBKC, we developed in 2017 and sits on Sloane Avenue, and again is an 8,000 square foot cafe, food offering, and a high quality kind of organic food store on the ground floor with 7 residential apartments above. I think the point I'm trying to make is we're highly invested in the area. My managing director actually lives in the area and is very local as well. We we are long-term holders in this area, and we want to see it flourish and continue to grow. And as part of that growth and improvement, we would like to incorporate a little bit more F&B and restaurant-type use into this location, because over the past 10 years, what we've seen is actually it's the one sector that hasn't actually continued to kind of increase here. We've got lots of lovely retail, but actually very few places for a mother and daughter, a family, to sit down and have a nice lunch or an evening meal. We are lacking a little bit in amenity when you compare this to somewhere like Westbourne Grove, in the northern area of the borough. And that's really the main driver for this change of use in the premises licence. We, as you've heard, I'm sure, in a number of different meetings, we have been through a difficult 2 years. We are also competing against the internet, and retail is difficult. And we are being asked by our retailers in this area, which now total kind of 30 retailers, and our residents actually, if we can bring more lifestyle, all-day kind of offers to this pitch to basically make people stay here. The footfall is quite low, and they would like to see more footfall that comes here actually stay in the area. And kind of then drilling down into, what we would like to achieve with this unit. We are not trying to achieve a stand-up bar. We're not trying to achieve I think there's a nightclub, we are trying to achieve an all-day offer restaurant, which could be at one end of the scale a Gales Bakery, to the other end, which could be a kind of ladderay, which is, kind of nice toasted sandwiches at lunchtime, evening meals, that serves a glass of wine or a glass of Prosecco with that, or, a lightweight restaurant. This is not going to be a big restaurant if it's actually been reduced in covers to probably more like 45 because of building regulations and things like that. So that's really why we would like to do it, is to kind of continue to increase the percentage of mix of different uses here. We finished the development in about 2018, where we actually excavated the basement further to create two very good retail units. Yes, they've been occupied as retail by 4 different tenants. All of those tenants have been paying a very low rent because they wanted to try the location before they signed up to a longer period. And the 4 tenants we've had in there have actually not paid any rents. They're on pop-ups, they've been paying business rates only. And the viability element of this is also a factor that we are trying to address. I think the key point here is when you have brands in our ownership like Boffy, who've just moved there, Chanel, Isabel Marant, Frame Denim is a New York brand that's just come to Draco Avenue. It is massively in our interest to make sure that whatever we lease when we lease these units, that we do not lease them to a tenant that is a nuisance, that is noisy, that is noise polluting, that is creating smells. We will commit under a separate planning application to have proper extract, proper air conditioning, and regularize all of that so that our residential stakeholders above us any interference or nuisance is mitigated as much as possible. We will have to provide acoustic surveys, proper attenuation. Any air conditioning we provide or extract will be moved to roof level and actually...
Sorry to interrupt, you have 1 minute.
Okay. And I think all I'm trying to say is in our interest to make sure that all of our retail tenants, residential tenants are respected and looked after, and we try to do the best for everyone. Okay, thank you.
Thank you very much. Councillor Addenbrook, do you have any queries or comments?
So you did mention on the conditions that you did not really want to consider, I think it was 27, about arranging meetings with local residents. I would urge you to reconsider that, because I think it's really, really important, particularly if you've got 2 restaurants side by side and you're trying to create this great atmosphere. I think just, people may not turn up, but I think offering it is really, really important.
Do you know what? I think that's a fair representation. We do quarterly meetings with our retailers generally, so I'm happy to kind of incorporate that into the license, because I'm down there 3 or 4 times a week. We have a dedicated property manager in the area. We do have telephone numbers, if there is something happening, please phone this number. But if Thomas, I'm happy to kind of...
If he's happy, I'm happy.
Look,
We'd have to,
we're respectful of everyone, and we want to. Everyone has to get on with each. London's a busy place, so. No,
I think we'd probably have to define a radius to make it reasonable, otherwise, you can't be expected to deliver it within in a mile radius.
Yeah.
So we have to decide what's sensible.
Shall we come to that in the conditions bit? When we come to the conditions bit?
Councillor Mason?
Yes, keep Mr. O'Malley happy. It's a good idea. Mr. O'Malley, when you were answering the objectors' concerns, you helpfully took us through the draft conditions. And I usually play devil's advocate and say these have to be operated by somebody at the premises, and presumably there is a management plan to deal with that, because of course at too many premises, you sound like it won't happen to you, but they agree a whole slate of conditions for dispersal and management of the premises, but in actual fact it's predicated on actual staff who work at the premises who are busy selling or doing other work to carry that out, and therefore they fall down. So I assume that the draft condition objectives that you have here, all staff responsible for selling alcohol, of course, will receive training and so on. That it is going to be the DPS of the staff who have to deal with this. Shall I stop there for a minute? Yeah. In other words, who manages all this at the premises day to day?
So in reality, this would all be managed by it would be the licence holder and the DPS, the designated premises supervisor. Now, with this application, obviously someone will sign the lease to take this site. Part of that process will be that they will be made aware of the conditions on any licence, if granted, by yourselves. That's obviously, they would need to then ensure that everything is complied with in terms of holding that licence. But also in terms of the lease, there are also specific clauses within any lease that will be signed which will direct them to ensure that all conditions with any licence or any other authorities granted by the local authority are adhered to. And so we as a landlord would, and we suggest that it wouldn't happen, but we're always going to say that, but if it were to happen, we actually have, we can act very quickly in terms of the lease to forfeit that lease and to basically change the locks. So in fact, and it would be in our interest anyway to do so, because if we did have a problem tenant, the reality of the situation would be that our other retail tenants in particular and our tenants who are residential tenants are going to be phoning up Mr. Morrison saying, what's going on? So we obviously wouldn't take favour over a relatively small unit of this compared to the others. So that, I think in reality that's how it would work itself. And just to be absolutely clear, although they're relatively small units, there is a lot of interest, not only from UK-based companies, but also international companies that want to have a foothold within the Royal Borough for obvious reasons. And so it's fortunate for us as landlords to be able to pick tenants that we think will fit the bill. And it's very important that, and what was mentioned earlier, that we get companies in that, we want a particular type of cafe or a particular type of restaurant that is going to sit well with, to be frank, the people that might go shopping in Daylesford Organic or in Chanel. You know, it's going to be something that, the type of offering we would suggest would be very low risk. I think that with all the conditions, and it's heavily conditioned from the application, and rightly so, because we do know the sensitivities of residents. Now, we would suggest that when we, in fact, front-loaded the application with our 27 conditions, which I would suggest is quite unusual for a unit of this size, we would suggest that the fact that local residents were informed of the application and through the letter drop, that reflects very well on the landlord and reflects very well on this application insofar as we have one objection. This could have been, and we've all appeared in cases where there's been dozens of objections and that hasn't the case. I think that reflects very well on the landlord and on the applicant as to precisely how they've gone about submitting this, and have really thought very hard about, and even in terms of the hours that are being requested, they are not the hours that are would ordinarily be in your policy, which is midnight. This is sales of alcohol stop at 11 o'clock. The premises would close and all customers would be off the premises by 11:30. So all of these little things have been done with the best of intentions and with a real, there's been a real thought process has gone in. It hasn't just been, we put in the application and see what happens. This has gone back and forth, and this has been something that's been in the pipeline, for probably about a year now. Thank you.
I heard someone mention insulation earlier, and I remembered that on page 17 in the July 2021 paper, which I think came from yourselves, premises shall not be used under the terms of the licence until it has been insulated. I assume that since July that work's been done, has it? The premises are properly insulated, are they, for the purposes of the...
Yes, correct. Yeah, correct. So, yeah, you have Kingspan installed on the ceiling between the ground floor and the first floor. I think just to Thomas's point, we engaged quite quickly early in the process with the flat owner who has the second and third floor maisonette. She phoned up and we had a chat, and I dropped her an email, and I think that's probably why she hasn't objected. The first floor flat owner didn't really engage until quite recently, and that's when I kind of dropped, I dropped her a further letter and just on, to give her a proper update on what the process was.
Just checking, and finally, I know you're not doing it yet, but there's mention of possibly delivery, courier service. I mean, if that happens, obviously you would have a plan to deal with that, because they can be horribly intrusive in areas. I mean, in my area, they're all over the place. Do you know if that's on the cards? I'm looking at the same letter, July 2021. Point 21, you say you're not, we may decide to provide premises holder if the premises holder decides to provide. So you're not doing it yet, but
no,
if you did, that's the sort of thing that drives residents crazy, and maybe your customers as well.
Yeah.
You would have planned, you wouldn't just let it happen, would you?
Yeah, exactly. I think you're putting us through quite a rigorous process. The planning team at RBK, Royal Borough of Kensington Chelsea, will put us through a rigorous process with planning. We are going to go through quite a rigorous process with the tenant that we install there because of all the things we've been discussing.
Thank you, Chairman.
I've got a question or two, and I think then our legal advisor, Mr. Lemasurier, will have some queries. First of all, nothing's been mentioned yet. Perhaps you don't know, but do we actually have the name of a licensee yet? At the moment, all we know it's 165 Draycott Avenue.
No, we don't. We don't.
Right. Second thing is you referred to planning application which you will make for the premises, and it could include various or propose various conditions about smells and noise. Right. So one, I take it you haven't done it yet, and secondly, the noise conditions would be presumably the standard, minus 10 dBA steady tone and minus 15 dBA tonal, varying tone, which would mean if you can hear it, you've got to turn it off.
Yes, that's correct. So on the planning, you're absolutely right. That is precisely what conditions that any planning permission would have, and they would be quite specific. There are, of course, conditions on the licence, which are slightly different, less scientific, shall we say, but in effect, in layman's terms, do the same thing. But I think they're deliberately put in terms that are more readily and easily understood by members of the public. I think that's specifically why they are drafted in that way.
Right, thanks. Well, yes, I guess so. But of course, we can't put in here conditions that planning can do. But I just want to check that you're planning to put that in a planning application, because that would also be very reassuring to any residents.
Yes,
And
of
same with
course.
ducts and all that. In fact, I'd like to use this moment to appeal to anyone who's listening and to have it minuted that if anyone has any problems with any premises at any time with noise and nuisance, is to please tell the council. We get a lot of people complaining at a hearing and we have no evidence. So I'd like that to be noted, that if anyone does have a problem, please tell the council when it happens. We have a report a problem page on the website. I think I'd like to hand over to Ms. Lemourzurier.
Just a couple of questions. What's F&B, first of all? You mentioned it. Food and beverage.
Food and beverage.
Thank you. And number 163, which you have the licence for, isn't operational. You've just got the landlord's licence, and hopefully, if the committee are minded to grant the same for this licence. In the future, when you do, will you transfer the licences to the
Yes.
Premises licence holder, and then possibly get a shadow licence for yourself? Maybe in the future, it's up to you.
Yeah, there's no intention of getting shadow licenses for these for either of these sites. We have considered, in the past, maybe applying for shadow licenses for parts of the estate, but we haven't submitted any applications. But they were for entirely separate reasons, and really it was at the start of COVID when there was a real concern that certain companies might go into administration for example, so that would protect a landlord's interest. But in this case, we haven't, and there's no intention at the moment, certainly, to apply for shadow licenses.
Okay, thank you. And just one final question. I know you mentioned in relation to the folding doors, you suggested from 8 o'clock, but on your opening hours, you've requested 10 o'clock till 23:30. I appreciate that's for licensable activities. When you're putting in the planning application, I don't know what the planning application's for, but I presume the hours will be different to cover the non-licensable activities. Can you explain the disparity? Why is it not 8 o'clock on here as well, just out of interest? For opening hours, albeit with alcohol.
It's only because I became aware of. Oh, I see what you mean. That why would we want to open early? It's only because, in terms of licensing, most applications, when they're submitted, are based on the hours that you would be using the license.
Okay.
And on the opening and closing, it's a reference to the opening and closing when the licensable activities may take place. Because, of course, if a licence isn't being used before 10 o'clock, well, then there'll be no enforcement against before that anyway. But for clarity's sake, if you were minded to include that condition, I think it would be sensible that if you were in agreement with us to allow the window to be open from 8 o'clock in the morning, that, regardless of what I've just said, it would be better that it's specified that, although there'd be no licensable activities obviously taking place at that time.
Okay, so obviously we can't change the opening hours to
I
an
think,
earlier hour
I
on
think
the
the simplest
licence,
way would
yeah.
be just to simply change the opening hours at, on the face of the licence.
Yeah.
So it says the premises are open from 8 o'clock.
Okay, so what are your proposed opening hours then? 8
Well,
to
on
9?
it was 10. It was proposed 10, which would mirror the licensing hours. But of course, as we accept, those opening hours only refer to the opening hours for the licence. It doesn't refer to actually what hours. Hence why councils, including this one, have conditions now saying the premises need to be cleared and everyone needs to be vacated half an hour after the licence activities have ended. Otherwise, you could end up with this prolonged period of time when people remain on a premises.
So apologies for the confusion. I think it was mainly some of these smaller restaurants are very flexible and are very nimble, so that they kind of serve breakfast in the morning, brunch, lunch, and then evening meals, and it was just to kind of... Apologies, sorry. Have I spoken out of
Sorry,
turn?
I'm Heidi Tickham, I'm a legal advisor. I just wanted to clarify what you were suggesting the licensing authority should do in relation to the opening hours. You can't change the opening hours that you've requested on the application. Because they've been consulted on and advertised.
Okay, well, but in terms legally, it doesn't... Whatever hour the licence says on the licence, so whatever hour it says on the licence in terms of the opening, wouldn't stop someone from opening at 8 o'clock, provided they didn't provide licensed activities, because the licence only starts at 10 o'clock, if that makes sense. So all I was suggesting, and I take your point that, yes, that on the face of the licence, you're absolutely right, that would have to remain at 10. However, in terms of the condition, you would be able to say on the condition that the window could be open from 8 o'clock in the morning. The only reason I was suggesting that to change the face of the licence was, I think, just for clarity. In any event, it's so minor in reality that probably what will happen is that whichever tenant takes this unit will need to apply for a minor variation anyway, because when they do their fit out, it's almost certain that there will be some minor changes in terms of fixed seating or whatever it may be. And at that stage, it could be clarified then. But I think at this stage, I think it would be helpful, as I say, if you're minded to amend that, the window condition, that it could be open from 8 o'clock in the morning.
And can I just ask one final question? What's the planning permission applications for? I mean, could it opening hours be put on that?
It's in terms of the shop frontage.
Okay.
Is that correct?
Yeah, it's actually just to regularise the change of use from retail to restaurant, which is permitted, but just to formally implement that, to seek permission for bifold doors at the front of the shop fronts to create that cafe-style unit. And thirdly is to install air conditioning units on the roof of the property to the rear, and extraction to mitigate any noise or smells from the ground floor.
Thank you.
I've got a couple more questions. One is relating to smells, if you like. One of the objections raised is having the smoking area in front of the premises, and that would result in smell of smoke rising up to the first floor, which I think is a reasonable objection. So what could you comment? How could you comment on that?
Well, I'm sure we all appreciate it. It's incredibly difficult. I mean, the condition itself is fairly standard. We appreciate the concerns that anyone would have. I mean, no one wants cigarette smoke going into their bedroom or into their living room. And frankly, we don't particularly want people smoking outside on Draycott Avenue either. But we're in the unfortunate position where, sadly, some people do smoke, and so we sort of need to limit that and control it. And Draycott Avenue is a public highway, so we don't really know, in order to control that element, how else it might be done. I would suggest that, I mean, and I'm sure it's the committee's experience as well, that it seems to me less likely that you're going to have a proliferation of people smoking outside this type of premises. Just from my own experience, and I'm not giving evidence here, but the conditions and concerns about smoking tend to be more in relation to drink-led venues, in particular pubs, etc., where you have lots of people outside and they might be smoking. And there are groups that are they call themselves the social smokers, but maybe it's a badly used term. But I think in fairness, I think it's unlikely that we're going to have a situation here. It is fair to say that, obviously all these things will be closely monitored, and obviously the residents will have our details, not only of those who would be occupying, but also the landlords. And then I know that, I don't want to speak out of turn, but I know that it's something that the landlord could take up as well directly with any tenant, if there was a problem, because, as he was saying earlier, it is not in our interest at all to have residents who are unhappy with that type of activity taking place that is clearly going to be upsetting, and for all the reasons that we know. I mean, nobody wants that. Nobody wants that. But it's a very long-winded answer that I'm giving you. But in terms of the condition, I'm not sure that we can really offer anything that's really going to assist you, any further.
Thanks very much. I suppose one could also argue that a passerby could just stop and smoke. So, but the other question I have is just to put it, for the record, put it on the table. I don't think there's actually much to discuss. It looks agreed, and that's the non-standard timings for New Year and so on. That's agreed? There's no problem about that? The non-standard timings are...
You've amended it to be 2 a.m. rather than
at the beginning.
So likewise, it's a fairly standard condition the committee will be familiar with. Environmental Health requested it was reduced to 2 o'clock.
Yep. It's basically, yes, to do open till 2 a.m.
Indeed, and it would just save any tenant the necessity of applying for a temporary event notice on New Year's Eve. But there certainly wasn't anything raised by the objector in relation to it, and the statutory authorities seem fine.
Okay, thanks. I think there was some internal correspondence I saw within the council about, wasn't that changing the hour? From 3 to 2 or something?
You're correct, sir. It was the Environmental Health Officer who wasn't happy, because we had suggested a standard 24-hour, all singing, all dancing, bells and smells, and he saw it and we got kickback, and so we obviously agreed with him.
Thanks very much. Councillors, anything?
All right, it's over to me then for conditions.
I think so.
Thank you. I know you've said that you're happy with the amendments to your conditions, 1 to 26, but I think there's just a couple of bits I just wanted to, just for the sake of the live stream, can I just read out the condition number and you yay or nay it, and I think some of them we might need to insert numbers. So condition number 1, are you okay with that? Number 2? Yes. Number 3 with my amendments?
With your amendments, yes.
Number 4?
Yes.
5,
Yes.
6, 7, 8?
Yeah.
9?
Yeah.
Now number 10...
we need to put in the amount of times it will be...
We need to put in, councillors, I don't know if you want to chip in here. It's to do with number 10, condition number 10, to do with sweeping and cleaning at least X times throughout the premises opening hours and specifically at the start and end. How many times do you want in between? How does everyone think?
Yeah.
Twice a day.
I don't suppose it'll be a lot of mess, but well, let's see. What is your proposal? How many times throughout the opening hours? 4 times. Pardon?
Twice.
Well, sorry. Let me just read it. So we're already agreeing to at least.
So it's once in the morning.
That's on top of
On top of the opening and closing.
The opening and closing.
Yes.
Once.
Well, there's no tables and chairs outside, I suppose. So
At this present time.
at this present time,
It's a very clean borough.
twice. Well, Mr. Morrison suggests twice. We'll take the twice, and not within 5 minutes of each other. Otherwise,
Thank you.
bidding war.
Moving on, conditions 11, 12 and 13. Are you happy with the times, especially the times in brackets? 7 o'clock?
Yes, I don't see there'd be a difficulty with those.
Thank you.
I mean, they're operational, and yes, they'll just, you know, whoever's the tenant, they can just arrange for their
To a call.
things at that time.
14, 15, 16 and 17. You happy with them?
Yes, they're all agreed.
18 with my extra G in.
Yes,
Thank you. 19, 20, 21.
yes,
22,
yes,
23.
Yes.
This is the smoking one. Maximum of 5 people outside.
yes.
So my only concern about that is if you've got the restaurant next door and they've got another 5 people out right next to each other, you've got 10 people.
How many on their condition, do you know?
They have 5.
They have 5 on there.
But there would be 2 separate operators. I mean, I suppose the same could be said that if we were next door to a pub, we could have 50 people. But look, as I say, I mean, none of this is fixed. I mean, you know, if you're unhappy with the 5, you know, I'm sure it's open to negotiation. But I don't think that in reality there'll be a great number of people standing outside smoking, going to what would be a relatively small either cafe or restaurant.
Moving on. 24 with my amendment.
Yes,
25 and 26.
yes.
Now, we've had, I think, moving on to 27, I believe Mr
27 I was
Morrison
corrected
agreed.
upon, which we agreed to.
You agreed that, okay, fine.
Could we just add that about the gap?
So at least 2 times a year with a gap of
5 months. Oh, let me just get my
between
draft
the
out.
meetings.
My suggestion would be twice per calendar year with at least 5 months between them, or fewer if held more frequently. So it's only an if. Obviously, you can't have 5 months between if it's 3 meetings in a year. What? No.
If there was a problem and you had a meeting and it was a problem was raised, you might want to have a second meeting earlier.
That's why I say if
Yeah.
yes, if there's more, then therefore the gap would be lower, fewer months between.
We can fine tune the wording. But
Yeah, we
you-
can fine
do you
tune the
agree
wording,
in
but the point
principle
is that it's twice a year.
It's twice a year with a decent gap. But then if an issue
Yeah.
arises, then that issue is resolved.
Yeah.
at a sooner
Yeah, yeah. We would hope that that you might have one meeting and that's it. If never happens again. You
Okay.
can call. Sorry. I mean, you might call the meeting, but as was said, maybe nobody turns up.
Okay, and in terms of notification, local residents associations, ward councillors, and what are your thoughts on the residents of properties above and beside?
That seems reasonable.
Is that okay? Thank you. Okay, number 28, you've requested to be kept
8.
closed between 2200 and 0800 the following day, so obviously the councillors can go away and consider that. And 29, you'd rather not have a challenge 25 policy notice because you think there's enough notices already and it's not the kind of premises.
It's just
that-
about aesthetics. I mean, it's not going to be a deal breaker, quite frankly, but we in our view, we don't think it's
So that's up to
necessary.
the councillors to make a
Yeah.
final decision on that. Okay, and one final thing that just cropped up for me. If you are going to do deliveries in the future, would you be agreeable to just a short delivery condition if a delivery company is used by the premises licence holder? Sorry, if a delivery company is used, the premises licence holder shall provide a management plan to ensure the neighbouring properties are not disturbed by delivery persons and their vehicles. Are you happy to have that? Okay. Any other conditions that you can think of that's cropped up? That's it for me then, thank you.
Well, it looks like we've come to the end of the meeting. Nice and short. Thank you very much, everybody, for attending. We shall not be issuing a decision today, so you're free to go if you like.
Thank you very much. And it was nice to do them in person again. I'm just used to your face appearing in my living room on a screen. So it's nice.
Yes.
So welcome home. Was this the first day that you were sitting as a live?
Correct. We decided to start today. It's very experimental.
Okay. Well, I hope it wasn't too awful for you.
I think we'll manage next time around. Thank you very much. Hearing is now closed.
Thank you for your time. Thank you.